Welcome, Deliliah. Welcome to the Dario Mambo Show. Thank you for being here today.
Oh, thank you so much for having me. You have a great reputation as an agent, so I'm very honored to be here.
Awesome. Thank you. So speaking of agent, you are in the real estate industry, right?
Yes.
Tell us a little more about what you do.
So we do a variety of things. We do a lot that comes into the door, mostly residential real estate issues.
Yeah.
Everything from landlord-tenant problems to builders and their contracts, reviewing contracts, breaches of contracts, misrepresentations.
So you're a
by
real
sellers.
estate lawyer.
Correct.
Nice. What got you into that? How'd you end up in that industry?
Well, interestingly, that's not where I thought I would initially go. But my first job coming out of law school was with Ed Goldner's office. Within that office is a tax lending business who works in, of course, the real estate industry because they put liens on houses for paying the taxes.
Yeah.
I saw that as an opportunity to expand, and I just got really interested in real estate.
So you kind of you didn't study law to get into real estate. You kind of became a lawyer and then worked for a company, got experience, and just kind of went down that path?
Right. No, I thought I was going to be a criminal prosecutor.
Oh,
actually.
wow.
So that's where I interned initially as a
No
law
way.
student. Yes. And then I realized that I don't know that I necessarily wanted to be placed in that specific category only. And so I thought, well, I want to do something different. I want to be kind of a free bird, right?
Yeah.
Because in prosecution, you can only prosecute, and it's, primarily criminal
Right.
prosecution. So I just didn't want to be segued into one category
Right.
of law. Yeah.
So you're a real estate lawyer, right? How do you describe the difference to someone who doesn't know, the difference between a real estate lawyer and a criminal prosecutor? Like, how different are those?
Okay, well, real estate is going to land you more so in the civil side of the law. There's two main types of litigation, pre-litigation practice. One is criminal and the other is civil in approaches to cases.
Got it.
Sometimes we'll run into real estate cases with some criminal elements, but for the most part, they're very, very different. In fact, we also end up many times in complete different courthouses here in Bexar County. You've got your criminal side, and then you've got your
one
civil.
case, it can go to two different.
Well, in the sense that criminal only practices in one courthouse, and civil ends up in the other courthouse.
see.
So we're typically in different sides.
What would make a real estate issue a criminal as opposed to like a civil?
Well, for example, we may get calls on the Airbnb next door or the renter next door is causing havoc and is trespassing onto my land and threatening me and the physical well-being of my family, for
That makes
example.
it criminal.
Right.
Oh.
So sometimes we have an associate that was a prosecutor. And so sometimes we'll segue into that.
Yeah.
We'll utilize her, resources for Ms. Jacqueline Ott.
Yeah.
And she can talk a little bit about the criminal aspect of the real estate case. While our main mission is typically to, take care of the real estate issues, which are going to be the trespass in that case or any other intrusions or nuisance issues.
Wow.
Yeah.
And so how long have you been in this industry?
So it's been since 2016.
Wow.
So I have been doing it for quite a few years at this point, enough to feel very comfortable with it.
Nice.
And
How
get
many
used to
years
it.
of practicing real estate law did you feel like, okay, I think I'm comfortable now and confident?
I would say probably into about year three.
Year
Year
three.
three. By year three, you've at least gone through a full litigation case, right? Because litigation will take about 2 years to complete from beginning to end.
Really?
Yes. And this is why I tell my clients all the time. If you're ever thinking of litigating a real estate matter, you have to go in understanding it is going to be very expensive and it's going to be long and drawn out. The justice that you might see, for example, in the criminal system, where you get immediate jail time, and there maybe are some delays there for trial, but a lot of times you've got plea deals and things like that.
Yeah.
You don't see that so much if you're going for litigation in real estate because you have discovery periods. There is an actual process that you have to go through. That's a real commitment.
So in litigation, there is a process that lawyers have to abide by.
Right. Right.
What would it make someone want to get into litigation? Like,
So there's actually 3 factors that I use, and I think everyone in society should use this when they're making a decision on how far they want to go into their legal case.
Yeah.
Okay. Whether they're your clients or anyone else in a weird real estate situation, there are 3 things that we look at. First is liability. Is the person that you're looking to sue actually is there causation for that person and their behavior, right? The other is, are there damages? Okay, so maybe they did something to you, but it cost you a $10 replacement of a light bulb or a part in your home, or or it's a wash because insurance covered it or something, right? And you don't really have any real damages, then it's not worth pursuing, because what are you going to get? A small judgment for $10, right? At the end of the day. The last thing is what we call big pockets. And so this is how we say it, truly internally and to our clients, is we say, if the person you are suing doesn't have any funds to tap into in case you get a judgment, so we could win all day, right?
But what do you
win?
And
you have a piece of paper, right? And then can't collect on that piece of paper, then is also not worth going to litigation. So I think if you've got those 3 factors, even as just someone who doesn't know anything about the law, those are the things you want to think about.
So what are those 3 factors again? Like,
it's going to be damages, liability, and big pockets.
I see. Wow. Yeah. Look at that. Yeah. In your experience, like, what's the first litigation case you had?
Well, one of my niches, it's kind of fell into me, is lending issues. So I tend to take a lot of lenders with what we call constitutional violations, in which they should not have loaned the money because of a violation. So that was a lot of the first cases I took. Foreclosures were very common too. So they're all intertwined with lending, foreclosures, defaults, things like that. Because I worked for a tax lender, when the borrower would default on those loans, I was the one to process the foreclosures, send the default notices as well. So those are pretty common in my first year.
So practice. A foreclosure even has a process, right?
It does, yes.
And it's the lender that's filing the foreclosure, right?
Right, that's correct.
And so what do real estate attorneys, what is their job role in that process?
So what they call us in the foreclosure process is the trustee. Right. A lot of times you'll have already an attorney listed on what's called the deed of trust, which is what is actually used to foreclose on you. A lot of people might think it's just the note or just that they exchange the money, but all your rights are listed in your deed of trust.
And so there's an attorney attached to that deed of trust?
There is.
So the attorney that writes that deed of trust is the one that has to foreclose?
No. So most deed of trusts will have an attorney as the trustee.
Right.
And it's a little self-serving on the attorney side.
Yeah, I can see. Yeah.
We just do it. It's a part of the process, and it's just norm. It's the norm. So it's not necessarily completely selfish, but the attorney who drafts it just puts themselves as the trustee.
Yeah.
Not a big deal
right.
if the lender goes ahead and decides to hire another attorney or that attorney is too busy.
But there's like a default attorney on that.
There is. There is. And then what you have to file is a substitute trustee document. And that's how you get someone else or another attorney to go through the process. Right.
Wow. Yeah. And what is the process of a foreclosure?
So first you get a default notice. So essentially, let's say you're behind, someone's behind 2-3 months on their mortgage. Yeah. The default notice says, hey, you're in default, you're behind, you need to pay the 3 months.
Yeah.
Okay. And then you have so many days to do that. Okay. Once those days expire.
How long does one take to get into that default? 2 months, 3 months? Is there like a standard?
Well, it all depends on how forgiving your lender is. So this is what's really important to understand, is that lenders and who you go with is going to matter tremendously, because after month 1, typically, you're in default.
Oh, I see.
So they can start the foreclosure process in most deeds of trust, right? Could have different language, but most deed of trust language says, first year, the first month you didn't pay. Yeah. We're going to go ahead and send you a default notice right away. The second notice gets you to acceleration. So that means we're not going to pull back unless you pay the entire loan amount.
Wow. Like a balloon payment. Pretty
quick. Yes.
Wow. And so you get the notice, and then what happens after that?
So then, depending on what type of foreclosure the deed of trust allows. Some of them are non-judicial. So right then the non-judicial foreclosures can go straight to another notice that's just a straight up foreclosure date notice. We're foreclosing on your home. So the process by itself can take, 65 days or so, and your house is on the auction block and it's gone.
So in the foreclosure process, what rights do lenders have and what rights do the client has or customer has? So
the borrower doesn't have much rights, really.
Because they don't really own it yet. They just...
Right. Well, not so much because of ownership, but because of the fact that they've already defaulted.
Oh,
once you've defaulted, unless the lender is wrong and didn't take care of their records correctly, and you really did make the payment, you really have no argument against the foreclosure necessarily. Right?
I see. In a foreclosure, how's the auction period look like? What is that? How's that like?
Well, it's a 21-day notice. Yeah. So that's a part of it's a default, then acceleration, and then the foreclosure notice. It then gets published so that people can look it up. Here in Bexar County, there's a website. Lineberger is the one that does taxes, but there's also another website where you can go look it up. You can also go to the sheriff's office and look up the list of the foreclosures.
Or even the county.
The county. Yeah. It might have been the county. I don't go there often. It's been a long time since I've actually had to physically go there, but there's a place where they keep the list. It's at the jail, the Bexar County jail.
Yeah.
So maybe it is with the county. And so you could look up to see if the house is listed.
Wow.
The borrower should also be getting a notice too. So they shouldn't be completely clueless that it's coming.
So they get a default notice and then either pay up or get out.
Right.
And then the second notice would be
the acceleration,
which is a balloon, basically pay it off or you're going to foreclosure. And then the last one is your auction date is set.
Right.
And then I've actually come across, because I used to go to the county office a lot, the Bexar County, and I would come across the auction every now and then.
Oh, yes.
And it's like they actually have it in the footsteps or in the lawn, right?
Yes, they do.
And why is that? Why is that?
Well, one, I think room. I mean, I think they do it outside on the lawn so that, because usually there's a lot of people who attend those things, right? And most of the courtroom is being used for actual proceedings. And so it's just easier for them to do it outside because they've got plenty of room. You just don't know how many bidders you're going to get that day.
Right.
At the auctions is where you're going to see all the investors, which I know we've all heard of, right? Investing is its own, way of making money now.
Right.
It's popular, and there's a lot of folks that are doing it. Lots of LLCs out there and things like that, and they're all going to bid on these properties. So sometimes it could be massive, the amount of people that are over there bidding on the properties. Yeah, and it's just as simple as someone throwing out a, hey, this is this property for this amount. The minimum bid is this much. Yeah, and then people are just there having signed up to bid, so you can't just go and walk off the street and do it. Right. Having signed up to bid, they raise their hand and go this much, this much, this much. So it's just like an auction. Yeah, and it's hard as on the real estate agent side or even investor side, because you can't just throw money out there and win it, because what if the numbers don't work out, right? So these investors really have to have the homework done and know about the property. So when they're auctioning the property, they know what the numbers are, what's the max they can really allow. And it's kind of scary because you have to do it cash, right? Right. You have to pay cash for these properties, but you get it at a discount, right? Man, you would hope if you're paying attention, you're getting one at a discount, right? Right. And so, what other kind of stuff do you do in your office that you have a lot of experience in? So we do other types of practices because they're so intertwined in real estate. So we do estate planning, we do probate, and we do guardianship. We also create LLC entities. Like I mentioned, investors all need LLCs. Yeah. So we just like to create them for our clients because most of them are needing it anyway. What are like one or two reasons why an investor would need a LLC? So it's just like how it sounds. So limited liability company. And one of the things, the exact thing that I tell them when they come into my office or talk to me about it is, hey, the idea is, if you are making money in real estate investing and you've got assets that are in your personal name or your wife's name or both your names, then you don't want, if someone sues you because something happens in one of your investment deals, which is not uncommon.
Yeah.
You get the phone calls.
Yeah.
Then you have a protection around whatever assets you have inside of that LLC. Being a real estate investor in general is a risky business, period.
Yeah.
There are ways that investors do their business, like wholesalers,
right?
Where they're promising to sell to someone else while they're booking themselves in a contract over here. That can be very dangerous.
Right.
Right.
They put themselves in a lot of risk.
Right.
Yeah.
One of the mistakes I see often by investors is somehow this seller finds out that you're selling their home for so much more.
Yeah.
And then gets very angry, and then you get a lot of litigation out of that part of it. So the idea is you're doing a risky business. You're in a risky business. It's just a part, and then maybe it's just par for the course. I think a lot of investors just take that on and go, it's just a part of that type of investing. It's smart to do it.
Right.
And I encourage investors to continue to do what they do. But they just have to be very careful with their personal assets.
Right.
Because while you may be making money in investing and spending them on things that give your family more, or you have more personal assets because of it, if you don't put that LLC, those assets inside an LLC, when they sue you, they have a right to, go after
everything
this
else.
Other house you have over here, and other assets that you might have in a judgment. So you become deep pockets.
Right.
You don't ever want to be deep pockets, just to kind of tie it into litigation. The investor never wants to be the deep pockets. You want to keep only, a lot of times what we'll do is we'll put one house in one LLC.
Right. And each one has its own little shield around it.
Right.
What's a best practice for someone not to, what I think the term is pierce corporate veil, right? The term meaning like if you cross mingle your personal and your physical and your assets, then they have access to that, right?
Right.
Can you tell me a little bit more about what that is?
Right. Me and my CPA talk about this often, John Buxey. We talk about how making sure, both when he's dealing with my clients and when I'm dealing with my clients, that we're making sure we're telling them, hey, if you have an LLC, don't be paying your personal bills with that LLC, right? Don't use the LLC for personal business. Don't intermingle your personal funds and what you're making at work, for example, and putting it into your LLC.
Meaning like if, because I hear this a lot, on YouTube and stuff, you can get like business credit cards to get line of credit, and you get a business credit card under the LLC, but then you use that business credit card to buy personal groceries at HEB or a trip to this and that, and that's kind of piercing the corporate veil, right? That's the term.
Yes, piercing the corporate veil. Yes.
Yeah. So you want to all your business accounts, all your credit card accounts associated with the LLC, just have it for the LLC. That's the protection, right?
Right. Absolutely. So you definitely don't want to intermingle those things. You have to be careful. You got to keep your business away from your personal, because we're always looking, and I say we, because sometimes we were on that side where we're the plaintiff and we're going, did they do something? So
you play both sides.
I do play both sides.
In some cases, you might have one client playing one side, another client playing the other side.
Yes.
I have a question for you. What's the benefit of estate planning compared to like having LLCs? Like, how is that different? You're still protecting your assets, right?
Well, estate planning doesn't necessarily protect an asset.
Okay.
What it does is that is the mechanism to determine what happens to your assets after you die. Now, I will tell you there are aspects to that protect it later on because of how you're doing it. The other side, which is the LLC, right now today protects your assets and puts it in a cocoon, and it keeps you protected from getting sued today, right? So one is protect me now and what I have now, so I have good well-being, and so that no one, gets access to only this one thing, and they don't get access to all my personal stuff. The other is what happens to my stuff after I die. Okay.
Like instructions.
Yes, instructions. This is who I'm distributing the property to. However, when I talk about protection assets, I think you hit a good point there, because sometimes estate planning, because you have a will, because you have a trust, protects your assets, because otherwise, if you don't have a will or a trust, then it gets distributed according to intestate law. So I have a video out that was really popular. We are very busy. We're a very busy firm. So I don't often get to do videos. I'm glad that I'm here today.
Nice.
So thank you so much. But there is a video I have that talks about intestate distribution and how things land. people don't realize a few things. They don't realize that stepkids will take half of a community property. If that husband or wife has kids from a previous marriage, right? Then those kids will take the other half. Right. So the spouse might have and hold on to their half, but they get to be the shiny new co-owners of a property that is now owned by the stepchildren they never talked to, for example.
Right. Interesting.
And maybe really dislike them.
Yeah.
I see that a lot.
Yeah. So that makes that transaction difficult to handle.
Right. So you can get protection in that sense, in the sense that after you die, if you don't have a will, you don't have a trust. Yeah. Texas says how it goes, but you never want to let the law tell you how your stuff's going to go. Yeah. Then you could lose that asset because they could fight so much. And we deal with a lot of this in our office. They could fight so much that they end up losing the property. It goes to foreclosure because no one wants to pay the taxes or no one wants to upkeep it. And so you could lose your assets that way.
Yeah, I've had some cases where family members had to sign off on the sale of a property that was the parents, and these children now are like older, right?
Right.
Not everybody agreed, but luckily there was an executor, that was able to sign off. But it just makes things much harder.
It does. Yeah.
Let's go back to property ownership and like the difference between landlord and the tenant, right? Okay. What in the case of renter and landlord, what rights and protection does the landlord have, and what rights and protection does the tenant have?
So the most common source for protections for either side of those are going to be the property code. So they're actually landlord rights and tenant rights, that are dictated within the property code. That's essentially our Bible in the landlord tenant, universe, if you will.
Are they like a lot of stuff, or is it kind of
clear? It's not a ton. It's just enough to talk about unlawful lockouts by landlords and the tenants, the requirements to do that. Sending eviction notices and the requirements to do that. Yeah. There's just process. I guess it's more process dictation than it necessarily is overtly rights. But you're either doing it right or you're doing it wrong. And so that's when those rights kind of come in for the landlord tenant. Like,
let's say, if talking about the landlord, let's say you're the landlord, you have a client says, I have a tenant that hasn't paid 2-3 months. I want to get him out of there. What rights do I have to get him out of there? Can I just hire security and kick him out?
Right. That's a very good question. And I hear that very often. And we go, no. Yeah.
So why can't a landlord do that?
So there are actually procedures for lockout by a landlord. And I say this carefully.
Really?
Because let me repeat again. There is a process for a lockout for a landlord. Yeah. But you don't want to do it. And,
interesting.
And yes, you can, but there are particular steps you have to follow. And I have won many a case on a writ of re-entry because the landlord didn't do it correctly. It is so distinct as to what needs to happen, what paper needs to be on the property door, what the content of that paper needs to be, where you have to put an address of where they're going to get the key back for the change of lock. So it really doesn't do anything for the landlord necessarily. It's also not as powerful as landlord thinks. Their powers are not as powerful as landlords automatically start thinking right away. We always have to, and I say always, but some of the phone calls we get, we have to sort of slow them down. We go, and a lot of the comments I get are, that's just not right. It's my property. Right. They're not paying rent. Right. So I feel that wholeheartedly. But our comment to them is always, we're a pretty conservative firm. I say, I would rather you take the default notice period, the petition period up to trial, that time frame, and do it right and get a proper judgment, than try to use some tool within the property code that I have many times pierced on the other side because it wasn't done appropriately.
Oh, I see. So for landlord, there's a process.
Yes.
And it's better to stick to that process because that's the surest way to the judgment that you want.
Right. Absolutely.
So that's why. So that's what the horror stories of my tenant hasn't paid and I can't kick him out. Right. Because you should try to follow that process to the T.
Exactly.
Okay, let's flip it to the other side. Say you're a tenant, and you're going through financial rough times, and you can't afford the monthly payment, but that's your home. You have family. Like, you can't live out on the street. right? What rights does the tenant have?
For a little while, especially during COVID. And I think rental assistance is still active. We're kind of flip-flopping. Sometimes I'm hearing the judges say that it's active and it's not. But there is rental assistance that has been offered. And I see that more than before.
Who offers this to the landlord?
No, but I believe it's the city. Don't quote me on that. Yeah. I most of the time are not, other than, them getting to there's a table that usually is set up. So just FYI for anyone who's interested in doing that, there is usually a table set up for assistance. And I believe it's the city who releases those programs and gives the authority to give that assistance. So tenants aren't completely alone in that process.
But that's a COVID situation, right?
It was. Yeah, it really came out of that. And it's sort of, we're still seeing remnants of that assistance still coming in. When I go to court on evictions, very often you will still have a representative from that organization who doles out that money, giving us status on applications of tenants. So it's still a thing. Yeah. So it's not completely over yet. So now that's a tool for tenants. Another thing is a lot of times tenants think it's done because, I don't know, they have stopped paying, but they've still not gotten an eviction notice. A lot of times I tell them, you just need to stay in the house until you go through that entire process.
Oh, right, to the judgment.
Watch me flip sides here.
Yeah, right.
So,
which hat am I putting on?
Which hat am I putting on? So the tenant side, if you have not gotten your eviction notice yet, if you've not gotten served a petition, if you've not gotten your trial date.
So those are things that you need in order for the tenant to comply.
Right. To properly be evicted.
Oh, wow.
Right. So to properly be evicted. So on the tenant side, a lot of times they're like, we need to move tomorrow. And yes, I mean, ethically and morally, if you are not paying your rent, I will say you really should be planning to move in the near future, if not as immediately as possible, because you are in default if that's the case. And we do tell the truth to tenants that are in the situation. You're going to eventually have to move out. So don't wait, don't sit, without planning, because you will end up on the streets.
Does a landlord ever get any damages compensation? I'm not sure what it's called, but all of those times, all those months they're not paying, the landlord has to pay. That's damages, right?
Yes, correct. So in JP court, which is where you have your eviction cases, so it's justice of the peace. We have 4 of them here, 1 through 4, different sides of town. So they just cover the 4 quadrants, if you will, of San Antonio.
Okay.
They have a jurisdictional limit of $20,000, and it's a part of the eviction process to say, hey, judge, we have 4 months. It's 4 months at $1,000. It's $4,000. So we want a judgment we want possession first, of course. And then the $4,000 plus attorney fees if you hire an attorney. And all those are up for grabs at that point. But it just cannot exceed the $20,000 limit.
But then, you're charging this to the person who's not paying. So kind of concept of pockets, right?
Yes.
So you might win the judgment, but you probably never get.
That's a very good point. And we do have that conversation with landlords sometime that a win is a win.
Actually becomes their loss because they have to pay for attorneys while if they don't, right? Something like that.
Well, yes, to some extent, yes. Right. So what you're saving for the only angle we really kind of are seeing on the landlord side is you're just getting them out, and that saves you money because the fastest they get out of the property, you're now able to re-rent it out, stuff like that. But if you're not following the process, you didn't hire a lawyer to do it, you messed up, and at the trial they go, tenant's right, you didn't give him proper notice, dismissed. You have to start the process all over again.
Wow.
Right. So the landlord hiring an attorney to do that, you could lose yourself another 2 months, 3 months, depending how long they're taking to schedule trials if you're not doing it right. Sometimes we will get cases where the notice has already been sent and we go, nope. And we have to just throw away that notice and we start all over again ourselves.
Wow.
Because we go, sure, we could, jump from your notice and go straight to petition. But if it's a bad notice, which we many times will review and say it's a bad notice, we want ours. Then we get all the way to trial, you're going to have a dismissal reason for the tenant to give.
Look at that.
Yeah.
That's crazy. Deliliah, out of 10, like an average of 10 landlords in San Antonio, right? Out of 10, how many of those 10 understand that process?
Ooh.
Like the common like there's a lot of common landlords, right?
I would probably say maybe 1 out of 10.
1 out of 10, and that's probably because they're experienced.
Yeah, maybe. Yeah, maybe they yes, they're experienced enough.
You don't become a landlord and have to go to school to learn how to be a landlord, right? So you can just become anyone can just become a landlord with not knowing this until you're faced with it.
Right.
Wow. Yeah. So and this is why you need a lawyer.
Right.
So why you need you.
Right. Exactly. And we say it's so much worth it. I get it that lawyers cost money, but so does time.
Right.
That's the thing with investors. That's what's really important for investors to remember. Yes, it's unfortunate that you're like not only losing rent, but you're also having to pay an attorney, just exactly like you said, which sort of feels like a losing position. Right. But at the end of the day, if you don't get a real estate attorney to do it, and it has to be a real estate attorney. We get into that a little bit too. Yeah. But if you don't get a real estate attorney to work your eviction, then the likelihood of that eviction failing is higher. And so you may end up getting a dismissal and you've lost money just because you didn't spend money on an attorney to do it appropriately. Right.
Wow. Look at that. Yeah. Man, well, I can go on for hours about this process, but I have a couple more questions while I have you here.
Sure.
You mentioned, you're a real estate attorney, and in our business, representing buyers, we have to sign a contract that we make an offer on. Whether we won't sign, the client signs it, but whether you're the seller or the buyer, and both seller and buyer has to kind of comply with the contract.
Right.
Now, one of the few things actually that we're always having to carry on our shoulder is the whole option period and earnest money, and what are you at risk of, and what do you have to gain if the buyer said don't comply within that paragraph of the contract. So in your experience as a buyer, let's say the option period is over, you have 1% of earnest money tied up in title, and you still want the earnest money back. Like, what limitations does the buyer have? What rights do they have?
Well, the buyer can't breach the contract. So if they're going to terminate the contract and they want their earnest money back, is that what you're referring to?
Yeah.
Okay. Then they're going to have to terminate within the option period.
But what if they don't? That's what I'm saying. Yeah. Okay. Or what if it's like 2 days after the option period, and they find out, I don't want this house anymore for whatever reason. There's always a reason. What
Tap
happens?
out, lose your money.
Right.
So what happens, in fact, is as soon as that option period is over, you are locked into that contract. And so, no. So you can't, as a buyer, obtain the earnest money back after that, at that point.
You can't? Or is it still up for negotiation? Can you ask the seller, sorry, forgive me? And
well, I'm an attorney, Dario. Everything is up for negotiation, right?
Right.
But if you're asking me black and white what the contract says, right, then there's a less of an opportunity just straight contractually to be able to get that earnest money back. Do you have a legal right to it? No. Is there a possibility that you have a great advocate like Dario to be able to say, hey, it's just that 2 days later, and there's sometimes reasons that can really make or break this trying to convince the seller to go ahead and give it up anyway. Right. And those will look something like this. And you may be familiar with them, having played the game on that outside of the option period side of things. Well, we did our inspections and a pipe bust 2 days after our option period. Had it busted within the option period, we would have known and relied on that information in order to get out of the contract within the option period. Something special happens outside. They can't deliver. So it's really about also the performance of the other side. Seller can't deliver your house. Seller terminates for some reason on the seller side. So I'm just talking about straight what the contract allows you to do after the option period, but we're not talking about the behavior of the seller. And there are sometimes behaviors that the sellers do where they can't deliver that product. They can't deliver that home the way that it is. Or now a tornado has gone and ruined the house. Of course they can't deliver the house. You're going to get your earnest money back as a buyer, right?
As a seller, let's say you get into contract with a buyer that's a 7-day option period. Day 6 is day 5, right? And then it's still active option, so people can still see the house, And next thing you know, you get another verbal offer. It's like, hey, I'm willing to pay twice as much as the next buyer. Does the seller have the option to breach the contract in the option period to get rid of that buyer to go with the other offer? Is that something that's like a no-no, or you can't, or you're breaching contract? What are you at risk at?
Well, I mean, the option period is usually for the buyer to back out. Yeah.
Right. In other words, can the seller back out?
No. No. I mean, the short answer to that is no.
And what happens if they do? What risk do they have?
Well, then the buyer can do what's called specific performance.
Right.
That's a beautiful legal concept.
Yeah.
Because what it does is allows the buyer to say, hey, we contracted to buy this from you, and you agreed in this contractual agreement that you would deliver this property to us for this price.
Yeah.
We're locking you in, and if you don't sell this to us, we will sue you for specific performance. Specific performance is a fancy way of saying we want you to do what you promised in the contract. Right.
Even then, like, what risk does the seller have? Because let's say the buyer wants to sue for specific performance, and this seller has 6 other properties. They can't go after those properties, right? They can only sue based off what's on the contract.
Oh, I see. Well, it depends who signed the contract.
Really?
If you sign the contract, the seller is an individual person.
Right. Okay.
Yeah. Then that takes us back to LLC protection, right? If it's an individual person, you're suing that seller as an individual person. It doesn't mean that because we're arguing about this one contract, I can only tap into that one asset. It's the person that you're suing that counts.
So the person has So if the person has, for example, deep pockets, then scary.
It can be very scary for a seller who's going in personally and selling under their personal
I heard
name.
a myth, maybe you can clarify this, that like the seller can be at most up to 3 times the earnest money. That's the most they have at risk.
Well, what you might be hearing there, and no, that's incorrect, because there are other damages that can result as a result of the seller not complying with the contract, right? And there are other causes of action we can go after them for. Specific performance is the main one. Breach of contract is going to be the main one.
Yeah.
But there are other equitable remedies that we use, and I say equitable, because that's the fairness part of the law, right?
I see.
And that's some ways how us litigators get in there, and we can get more different types of damages from people that maybe we wouldn't be able to get just under certain causes of action.
Right.
But, as far as the actual real estate contract goes, there are particular, causes of action you can go after. Specific performance is probably just the most popular one. But a lot of times we'll throw in, that they had to move out of their house. They sold their house and move into an apartment that cost 3 times what they were paying in their mortgage. And so that caused them more damages. The fact that they didn't sell this property to them. Right. So no, what you might be hearing when it comes to 3 times damages is a very popular cause of action that we use when a seller misrepresents, which sometimes we will throw in. And that's called Deceptive Trade Practices Act.
Right.
That's where you get the triple damages. Triple damages, a lot of general counsel or people, lawyers who do not practice real estate law will think that is just some easy thing to get, and it's triple damages, and it's for sure triple, and we're going to get you for, and the reality is you have to actually prove that there was actual knowledge and intent to misrepresent, right? Some cases very easy to prove because it's like you either knew it or you didn't, and then you had to have known it. And then some stuff, it's things like flooding in a house, plumbing that bursted, and they're like, I didn't know anything about the plumbing issue, and so we're like, if they didn't have direct knowledge and we can't prove that, then we're gonna pull it back, and we're not going up to the triple damages level. Right.
So in other words, let's say seller knows that there is something wrong with the roof or AC, right? And tells the seller's agent, right? But they didn't want to disclose it under the seller disclosure because they know they won't get the most out of the contract or the offer, right? And then buyer goes into contract, and it's 1 or 2 days before closing, and next thing is blowing up. They find out, they learn, and then now the seller's on the hot seat. He's like, "Did you know?" And if he did, you're in trouble. And if you didn't know, like, what is so in other words, if the seller knows and then the buyer wants to either come out of the contract or maybe even sue for deceptive, right? And then that puts the seller at risk, right?
Right. Absolutely. I mean, I always rule of thumb, and I talked to a client about this yesterday.
Yeah.
When in doubt, disclose.
Yeah.
There should never be anything that is left out of it. Even if legally you're not required to disclose it, and it's something like a really bad neighbor with 160 police reports, or other things, disclose it.
Yeah.
Let them know, yes, maybe it might not be a legal requirement, and I don't remember the law on that, but it may not be a legal requirement to do that. I mean, because that may be just discovered through due diligence by the buyer, right? But if it would bother you to purchase a house, then it just saves you from liability later and getting sued later, because the more
you disclose, the less you have to protect yourself.
Right.
Because you're letting it out on the table, right?
Right.
I'm gonna tell you a story or a situation, and you tell me like, how would you advise the client? This is for a buyer.
Okay.
The buyers find a house, they make a bid on the house, they make a 50% down payment on the house. And then they waive the right to an appraisal, to terminate due to appraisal, right? They waive the lender's right to terminate for the appraisal. A few weeks later, the appraisal comes back like $60,000 below the offer price. Buyers then are like freaking out. They knew they overpaid, but they didn't expect it to be that much. Yeah. So this is already past option period. This is like midway in, right? And of course, they waive the lender's right to for appraisal. I think it's
to terminate because of the appraisal.
Yeah. And so now they want to back out, and they're backing out. Meanwhile, the seller, because they've been under contract now, they're moving to Dallas, and they're under contract over there, right? And so now that this buyer's pulling out, it's preventing them from buying that house, and then those sellers are actually under contract on another. So it's like a domino effect.
Yeah.
Next, you know, the buyer gets a letter from a lawyer saying that either pay up or they want to sue or pay, like, I think it was like $10,000 or something like that. And the buyer then is like, what did they do? They breached the contract. Do they pay this strong arm, kind of offer, like, pay us now, for the damages that you caused, or we'll take this to court? Like, what would you recommend?
There are so many factors there. So I'll say this with a disclaimer, right? Whenever we are taking in a consultation or an intake, right, where someone comes to us just the way that you are, and you're saying, these are the facts, so this is what's going on. Usually we follow up with a whole lot of questions
to get clarity,
on the exact situation. What is their financial situation? Can they do something? And then we lay out really what the risks are, right, of not performing under the contract. One of the first things, with that disclaimer, let me just say, because we're assuming a lot here, and I can't ask those other follow-up questions, right? So let's just think on a basic level. One of the first things we will speak to is going to be the black and white contract. You're breaching. That's bad.
Right.
Breaching is bad. Yes. You took the risk, and you took on the possibility that this could happen. Maybe, and we can't turn back the hands of time. And I tell them that too. We can't go back and make you make a better decision on this, right? But this is just where you are. Can they sue you? Yes, they can. So we kind of let them know initially, this is the reality of your situation. You did breach. You are liable. It's a pretty clean liability case, because you were either buying or you're not buying, right? You either terminated appropriately or didn't terminate appropriately. So, and what I mean by terminating appropriately is just kind of what you were talking about. You terminate during the option period.
You're fine.
That's appropriate to me, right? As far as me protecting my client as a buyer. Good. You did it during the option period, clean. Let's get your earnest money back, moving on, right? When you terminate inappropriately, I see that, okay, that means you're breaching. You're terminating when you really should be performing. So when you terminate, you're actually telling them, hey, sellers, I'm breaching now. Here's my notice that I'm breaching.
Yeah, basically.
That's really what it is. It's like, you just basically told him you're preaching.
Yeah. If you want to sue me, this is the reason why you can.
Yeah. So that's your breach.
Yeah.
They're going to have a clean case against breach. So the lawyer knows that. Right. And I don't know. A lot of times we do a lot of speculation.
Right.
Do you think these sellers are the type that they're going to go all the way to litigation?
Right.
Sometimes we think, what assets do these sellers have?
Right.
Are they investors or are they just a couple that's retired who doesn't really have the funds to pay attorneys? Right. And that's the reality of the things we think about as attorneys. Do we think they're going to litigate against you? Yeah. Right. And so we say, okay, well then, and sometimes our advice may be walk away. Right. And let's just test it. We're litigators. We'll come in and defend you if we get there. Right. We don't think they're going to. Yeah. We'll give them the earnest money. Yeah. And then walk away and then see what happens. Yeah. Right. We'll sign the earnest money release and walk away if we really don't think they're going to litigate. Right. Sometimes I'll know the opposing counsel on the other side. Right. And so that'll also, weigh into the factor. Yeah. Other alternatives is we can negotiate. Is that because
you can kind of agree to a settlement easier when you know the opposing counsel? Like there's easier way to get to the finish line.
Yes, sometimes you can tell, well, this attorney likes to do this. Yeah. This attorney likes to. I try not to be predictable that way. Right. Most of the time they don't know what I'm going to do. Yeah. But sometimes you do. They're like, okay, with these kinds of cases, I've dealt with him before. We've worked together, let's say on something else. And this is what they tend to like to do. Maybe we can make this happen in this case. Yeah. We love interestingly, our opposing counsels, I understand they're advocating immensely for their client. I'm going to advocate immensely for my client, right? And at the end of the day, we're all making the right calls for our client, one way or the other, okay? So for me, it's just when it comes to advising my client, all those factors go in there, including knowing what the opposing counsel might do. Or sometimes we'll talk on the phone, opposing counsel, well, we're definitely going to sue. Or they'll kind of like share, like, this is probably something maybe we need to settle, maybe, whatever. Nice. All of that, the condition of my client, the condition of their client, who is opposing counsel, how bad is the breach? What's the gap in the monies?
Many things to consider.
Lots of things to consider. And that's why I say it's hard to always just take a fact pattern and just roll with it. Yeah. But they have the option to negotiate. They have the option to actually perform, find that $60,000 somewhere and fill that gap and perform. How much do they want to avoid litigation? Yeah. Is the big question.
Well, it sounds like you have a lot of experience, just like a wealth of information. So let's kind of take it back. What would you, the Deliliah now, what would you tell the Deliliah when you first get started? Do you run your own practice or do you work for someone?
I do. So I have my own law firm, right? We started in October 2019. Nice. Of course, I did real estate before that. Yeah. But I had actually gone solo in October 2019. Ever since then, we've been going strong. The real estate industry is a busy one. Real estate law in general has been immensely busy for our firm, and I'm sure lots of other real estate firms here in San Antonio have lots of colleagues.
If you're a lawyer, you want to get into a busy industry inside law, get into real estate.
Yes, in real estate. Yes. We're okay with having the company, right? There's plenty of business right now, and always has been. Very quickly, when I started the business, I think I was in 3 months. I had an intern just helping me answer phone calls. And then about 3 months in, I couldn't keep up with the legal work versus answering the phones. Right. So I had to get a paralegal very quickly when I started. Since then, we've grown. There's 3 of us attorneys now. I have 2 associates, Michael Palaciano and Jacqueline Ott, which bring a wealth of knowledge from different practice areas. Which is how I like it. I like bringing people in that we mold to our brand and who we are. I think they're good people, but they also have expertise in other areas, which helps bring in just a wealth of knowledge. Like I said, Jacqueline does has history of criminal and CPS law. Michael Palaciano works in
so use your strengths to provide more value to a client.
Right. So it's a nice team because we really are able to kind of, bounce things off of each other because we have different kind of backgrounds. And I like that variety. I don't like to assume that I am that all I do is just as perfect as it needs to be. And it needs to be a carbon copy of me. No, there is creativity in the law, especially in real estate law. It allows you to be creative. give neat, interesting, creative solutions to weird, interesting, dramatic problems. And so sometimes you need a different viewpoint to help do that. So I always call it a collaborative environment. That's what we like to do in the office. We collaborate all the time. What do you think of this? What do you think of that? And there's strength in numbers. So there's 5 of us now in the firm.
Wow. Look at you. From like an assistant to now having 5 associates?
There's 2 associates, a paralegal, so 2 more associates. So there's 3 of us attorneys. I have a paralegal, and then I have an intern that comes in. And very often my interns do become my next lawyers. So he's training up Stephen. He's at St. Mary's now, Mr. Nicholson, and he's doing a fabulous job. And so he gets to see what we do every day. And so essentially by the time he becomes an attorney, he'll have all the information he needs. He'll know how we work. He'll know how to draft. He's won a couple of MSJs, motions for summary judgment. He's written some with me. I love teaching, just the same as I love doing things like this. And I love that you have that same spirit, Dario, because I think a lot of people don't know things, and that's a weakness for them.
Right.
And there's a place that I call the gray. The gray is what I call when people are so scared of a legal issue or something going on in their life that they're almost afraid to get educated in it. But once they know it and someone outlines it for them, like you do, I'm sure for your clients all the time, hey, the buying process can be scary, the selling process, but this is how it works. I'm going to talk you through it. You're going to get through it. And it's like clouds lift. Yeah. Right?
The water becomes clear. It's not murky anymore.
Yes. Right. Yes.
So what would you tell, and to wrap it up, the final question, what would you tell an aspiring someone that's a law student that wants to get into the industry? Like, what would you tell that person, like they're watching now? Like, what kind of personality or character do they need in order to be successful in the real estate law industry?
Learn how to talk to people. If you've not done enough networking, getting to know new people, you need to start now. Because there is a big part of what we do that has a lot to do with emotional intelligence and the ability to relay how people feel, to understand how people feel, to talk through problems in a way that makes sense. Not talking above them. I know that there are various types of attorneys, and in real estate, you have everything from grandma whose son is trying to kick her out of her house, right? To to a real estate investor or a large broker who is very familiar with the real estate industry and things like that. So you need to know how to connect because real estate has no boundaries. Real estate is not just a rich person's business. Right. There are grandparents who fully own their homes. They're wealthier than much of America is because not everyone owns their home. Right. And so you will find, wealthy people that may not have the knowledge that someone, that maybe is, in a business that does make them a lot of money. And so therefore they have the knowledge every day because they work in real estate, right? Whereas grandpa and grandma, they fully own their home. I don't know that they realize how wealthy they really are for that. Because wouldn't we all not want to have a mortgage? Right. But they just don't know, and they need that guidance, right?
So to be able to talk to people, communicate with them, have emotional intelligence, and maybe a passion for educating others.
Yes.
Nice.
Yes.
Well, with that, we'll wrap up. Thank you for your time.
Thank you.
And